To help us break that verdict down, we'll turn to our guest this morning, Jonna Spilbor, who is here with us. Good to see you, Jonna.
Good morning.
So this was guilty across the board. First-degree intentional homicide, which in Wisconsin does not require premeditation. It does require intent. Hiding a corpse, guilty there, and also guilty of taking or driving a vehicle without consent. I don't think this was a surprise, given that the co-conspirator, Jamari Cook, basically said that he witnessed all of this. And the defense did a decent job of pointing the finger back at Cook and saying, well, wait a minute, you were involved with the two lesser charges. How are we to believe you when you're saying that you're not the one that actually did kill her? But I think it was the text messages that sealed the fate of this particular defendant, Daniel Tate.
You know, this is funny. I started shaking my head. I did not know the jury came back in such a short period of time. You said 90 minutes it took them to render a verdict. I predicted it was going to take them about 9 minutes because I thought the evidence was very strong against both of them. But really, you know, we were on trial for Tate. So this is absolutely, positively no surprise. Senseless murder. I think the jury got it right.
Yeah, you know, in the initial stages of this, I was back and forth, and I was saying, okay, you know, maybe Cook was more involved than Tate. Maybe Tate was more involved than Cook. How do you slice and dice this? How do you determine who's guilty of what charge? But I think it was the text messages from Tate's phone and then his behavior afterwards, trying to dispose of the vehicle so quickly. And then he said earlier, okay, that he wanted to steal a car or two and then apparently get a job and somehow, you know, parlay the money into to some kind of better life for his girlfriend who was bearing his child.
Yeah, and
I mean, it's sort of a twisted thought process, but the text messages and the social media records were pretty clear that that's what was going on in this guy's mind.
He wanted to, quote, flip the car to get some cash. And if I'm remembering correctly, because I was here covering it with you guys last week, he drove the victim's car to the hospital where his girlfriend was giving birth, which is just to add a little insult to injury there.
Yeah, I mean, talk about it. Wow. I mean, so look, I think that those text messages are what ultimately sealed the fate of Daniel Tate. But look, Jamari Cook, he's in court again today. I don't know if we're going to be able to bring it to you, but he's got a status conference. There he is testifying. Right. He basically admitted directly on the stand, hey, look, I did indeed help hide a corpse, and I did indeed take or drive the vehicle without consent. So he got up on the stand and said, yeah, I did those two things. I'm wondering if this status conference is going to turn into a plea session.
Oh, without a doubt it's going to. I mean, look, the prosecution needed his testimony in order to seal the fate of Mr. Tate, right? And they got it. So I'm sure that they were, now that they have a conviction, if there's any leniency to be had for Mr. Cook, it's going to happen now in the form of a plea deal. That's without a doubt. Although I will say this, you know, the defense rather had a decent, what we call third-party defense because of the involvement of this co-defendant. Like, when you have a third-party defense, if you can squarely point your finger at somebody, it brings more credibility to that defense. It didn't work for Mr. Tate, but it was a decent defense.
Yeah, again, I mean, I think it was the text messages. So the testimony from Cook sort of fleshed out the whole state argument, but it was the text messages. This is what I want to do. Then the communication with the victim, and then the actual acts. Everything just lined up. This was pretty open and shut.
Right. He basically gave a blueprint of the plan in the form of text messages, and it came back, obviously, to bite him, as it should have.
Yeah, we're going to turn our attention now to the other case that we're covering here at the Law and Crime Network. This is the Kwame Richardson and Henry Hayes case out of Florida. This is a case where two alleged gang members are accused of opening fire, hoping to hit the uncle of the 22-month-old Aiden McClendon, who ultimately became the victim in this case. This trial has been going on for a while, and it's an interesting case because we couldn't bring you the testimony of a couple of the witnesses because they feared their own retaliatory gang attack. Let's get you up to speed on this case as we get ready for closing arguments in a few moments.
Only 22 months old, baby Aiden McClendon's life was taken in a flash. Aiden's mother, Tamisha Brown, became emotional as she recounted on the stand what she saw from inside a car with her baby boy the night he died.
It was the one guy that I saw in the back seat. And then, Henry Hayes.
You have two shooters. Who was he in that car?
He was in the back passenger side.
Okay.
He was the one that was actually leaning out of the car.
Okay.
Henry, that's the person that was in the back seat.
Okay. shooting a gun?
Yes.
And did you write a statement on that photograph memorializing?
Yes.
And what was that?
He shot and killed my baby.
Kwame Richardson and Henry Lee Hayes are now on trial for the little boy's murder. Prosecutors say the suspects participated in a drive-by shooting, which led to the unintentional death of the 1-year-old. Investigators believe a gang conflict is to blame. Jurors were shown a music video filmed by the gang that both defendants were allegedly a part of. Prosecutors believe the intended target and cousin of baby Aiden was affiliated with the rival group. Both defendants now facing charges of second-degree murder, 2 charges of attempted first-degree murder, discharging a firearm from a vehicle, and shooting or throwing deadly missiles. For Law and Crime, I'm Dan Abrams.
Just to bring you up to speed on what's happening in that courtroom right this second, apparently there is a motion to dismiss a juror in the Henry Hayes case. Again, 2 defendants, 2 separate juries. One of Hayes's jurors has been seen wiping tears away several times, one time during the medical examiner testimony. There's also one other time. So the judge is going to bring that juror out and ask her if she can continue. Jonna, look, this is the end of the road here.
Yeah.
We're getting ready for closing arguments, and a motion to dismiss a juror at this point seems like a pretty drastic remedy.
Yeah, it does. And I don't know how likely it's going to be simply because that juror is showing emotion. There are plenty of other valid reasons to dismiss a juror, Aaron, as you know, if they're committing some sort of misconduct, if they're doing some research on their own that they're not supposed to be, talking to people they're not supposed to be talking to. But jurors are human beings. And I'm going to be honest with you, and I told Jesse this last week, when I was doing my research for this story, I teared up. It's an emotional story. A 2-year-old lost his life completely unnecessarily. It's sad. I don't think that in and of itself is a reason to disqualify a juror, to dismiss a juror. She's probably not the only one. The others could be crying at home. So What are you going to do there? Tears are tears.
Exactly. I mean, this is not the sort of case that's sterile. It exists
Exactly.
in an emotional gap. And, you've got the pictures of the 22-month-old being shown in court. You've got all this discussion of gang connections. We had gang members up on the stand testifying that they themselves fear for their own safety based on their testimony. Court was closed, so we couldn't bring you coverage of some of that testimony. Look, this is a trial with a lot of harsh angles.
Right.
But we want to listen to some of the testimony of Cynthia Hayes. She is Henry Hayes, one of the defendant's sisters. She was on the stand earlier in this case. Let's listen to some of her testimony. Welcome back to Law and Crime, everyone. I'm Aaron Keller. We are preparing for testimony to pick up, if indeed there is more of a case to be presented, in the Richardson and Hayes case out of Florida, a case of 2 defendants accused of shooting 22-month-old Aiden McClendon in a retaliatory gang attack. Those are the accusations, and we're waiting a while for court to pick up this morning because a judge is questioning one of the jurors who became so emotional at several points during the trial that the judge is trying to figure out whether that juror should be allowed to stay on the case. Jonna Spilbor is here with me on the Law and Crime Network. So, Jonna, look, the judge is really taking some time to question this juror to see, I guess, if the juror can still be fair.
Yeah, and, like we mentioned before the break, I don't care how emotional a juror gets. I don't think that in and of itself is grounds to disqualify one, especially right before a closing argument. Now, look, it won't mean the death of the case because I'm sure there are alternates, somebody who could step in and take the place of that juror. And jurors are human beings. This case does evoke emotion because the victim is so young and so completely innocent, and the killing is so senseless. Of course people are going to have emotions about that. You don't want jurors to be robots. So I think the judge is doing what he has to do kind of pro forma, but I think this juror is going to end up staying on the case.
Well, look, I think what the judge is trying to avoid here is a juror who's going to say, I feel bad for this victim, and therefore I'm going to convict these 2 defendants,
right,
which is what the judge is probably afraid of, because that's not a grounds for conviction. Sympathy for a victim is not a reason to convict a defendant beyond a reasonable doubt.
Right. But you can have all of those jurors feeling the exact same way. This is one of those cases where if a jury is going to err on one side or the other, they probably will err on the side of conviction because this is an emotional case, because you have such a young, innocent victim. Just because they're not crying about it in the jury box doesn't mean that the thoughts aren't going through their heads.
Yeah, that's true. That's true. Okay, so just to let everyone know what's happening in court right now, here's what we're expecting. We're expecting the state to wrap up its case in short order here. We were expecting it to happen first thing. Apparently, the word we're getting is that the defense was not going to present a case. We're going to have to keep an eye on that. So what we were preparing for, folks, was for the state to rest, the defense to rest, and then for closing arguments to begin. That's what we were expecting, but we never know. Maybe the defense will have a case. Maybe the attorneys thought about it over the weekend and wanted to present a witness or two. So we are in a holding pattern until the judge straightens out the situation with the juror. The judge asked no audio, so we can't listen into the proceedings. That's why we're recapping what we're hearing and not bringing them to you live. So while we wait for everything to sort of pick up and get rolling here, more testimony from Cynthia Hayes, the sister of defendant Henry Hayes. Testimony there in open court from the sister of defendant Henry Hayes. And there she's saying, hey, look, I was in the car. The defendants told me what to do with the gun. Jonna, this is the kind of stuff jurors love. This is someone who's got an eyewitness view. Oh, Henry, my own brother, told me to put the gun on the floor and asked the other co-defendant about the gun. I mean, this makes this pretty tight, I think.
Yeah, it makes it a little tighter than it is. You know, this is one of these cases where there are several dots to connect, but these dots are not in a straight line at all. So the jurors have a lot to contend with here. So every little piece that the prosecution can give the jurors that would indicate that the people that they have on trial are the actual culprits will help. This was very helpful testimony. I don't think it's going to make the decision for the jurors, but it was very helpful testimony.
Well, look, a couple of the witnesses we couldn't televise because they feared gang retaliation. Okay, so that testimony was closed. One of the witnesses was stabbed in jail right before testifying. Okay,
Yeah.
I believe it was the day before. And got up on the stand and basically said, look, I'm going to violate the no snitching rule. You know, that's pretty serious. I think, you know, jurors are probably going to put a lot of stock in that particular witness's testimony.
The witnesses who testified that we weren't allowed to cover for that reason are probably the most essential witnesses in this case. Here's what bothers me. Jurors might also feel that they're in danger if they come back with a guilty verdict. I mean, it's not beyond the realm for them to put two and two together and say, this involves gang violence. We got witnesses who can't be televised. Am I in danger? Because you know, we can find out who a juror is. It's not that hard. So I think that's also going to color what they do in that deliberation room. And that's a shame, but I get it.
Yeah, well, okay. Well, we're going to continue our review of Cynthia Hayes' testimony. This, again, is the sister of defendant Henry Hayes. And another interesting point of this case, again, two defendants. Each defendant has a separate jury, and depending on where the witnesses are in their stories, the juries are let in, sent out. Sometimes there are two juries in the courtroom, sometimes just one jury, and they tend to trade back and forth. So, look, this is, Jonna, sort of an interesting procedural quirk to some of the cases we watch in Florida.
I think it's very, very unusual and a little confusing. Like, who's making the call? How do they know when one juror has a jury, not just jury has to leave and another one comes back in?
I mean, this is being choreographed.
The
this is according to a script. Okay, you can tell that the prosecutor who is handling this is used to doing it this way and has everything lined up so that this question won't be heard by that jury and whatnot.
But Aaron, I got to tell you, you know, when you try cases, things don't always go to script. Some things can go off the rails. And then what happens if a witness says something that one jury should not have heard? Now do we have grounds for appeal? And it's going to get all kind of crazy. I don't know why they didn't just separate the trials to begin with, as normally
Makes
happens.
it tougher for the witnesses, and it seems that may be what they're worried about. So we're going to take a quick break here on the Law and Crime Network. We're waiting for testimony to pick up in the Richardson and Hayes case. We'll be back right after this. So there you have a law enforcement official saying, hey, look, I had consent to search this vehicle. In it, I found this Glock pistol. Jonna, murder weapon? What do you think?
Well, you know, that's the implication, but we don't exactly know yet. I found this witness's testimony very interesting because he asked for consent to search the vehicle, which is probably the only way he would have been in there because he actually stopped the vehicle for having a broken taillight. So he found a way to stop the vehicle when he had been surveilling the people from inside a restaurant. He wanted to pull over that vehicle. That gave him the reason to the broken taillight. Then he got consent to search. He would not have been able to search, Aaron, without that consent. And I'm kind of surprised that he got it.
Yeah, I mean, that surprised me too. But that's how he got it. So look, he did and found this Glock pistol. So Christopher Poole, we're going to pick up with his testimony in a second. But just to let folks know what's happening, I think they might be in the process of getting all the jurors together in the courtroom to try to pick up today. The juror who was being questioned by the judge about being too emotional at a couple of points in this case and who was a subject of a motion to remove that juror, apparently the judge found that that juror can continue, and the judge wanted to read some curative instructions to the jurors, probably reminding them, using the same language he did at the beginning of the case, to judge this case based not on emotion, but on the facts of the testimony. That's my guess as to what's happening right now, based on the judge's ruling that this juror will be allowed to continue and be a member of this deliberating jury. So again, we're covering the Richardson and Hayes case out of Florida. Two people who were teenagers when they were accused of shooting and killing a 22-month-old child as an unintended victim in a gang attack. Those are the accusations we're waiting for court to pick up. So back to Christopher Poole as we wait for the actual testimony to begin today. Very brief testimony from that detective, David Scott, in the case of Kwame Richardson and Henry Hayes. I'm here with Jonna Spilbor. Look, we heard that this might be closing arguments coming right out of the gate this morning, and now we've got the second of at least two witnesses and a third witness about to take the stand. Seems to me that somebody was doing a little strategizing over the weekend, that the state wanted to make sure that they buttoned up a few points before giving a closing. I'm
with you on that. The prosecution probably sat around and said, all right, what are we missing? Is there anything else we can get from the witnesses that we've already disclosed that come back and give us additional information? That's smart. You don't want to end your case before you end your case, so that was very smart.
Yeah, strategizing over the weekend, folks. We've got another witness about to take the stand now. Again, Kwame Richardson, Henry Hayes. They were teenagers when they were accused of pulling the trigger and shooting and killing a 22-month-old baby. We have a firearms expert on the stand in the murder trial of Kwame Richardson and Henry Hayes, two people who were teenagers when they were accused of pulling the trigger of potentially one of those weapons, I should say, and killing a 22-month-old child named Aiden McClendon. Jonna Spilbor is here with me on Law and Crime. And Jonna, look, we're starting to get to the point where this witness is making some points here.
Yeah, this is important because what we have here, look, this isn't an open and shut case by any means. We have 3 bullets that went into a 22-month-old victim. We have a gun, and we have somebody who was pulling that trigger. We need to connect those dots, Aaron. So right now, this expert is helping to determine whether the bullets that went inside this poor little victim came from a particular gun. And then next, the jury's going to have to decide who was holding that gun when those bullets exited it.
That is what we were hoping gets cleaned up in testimony this morning in the Richardson and Hayes case. We're going to take a quick break here on Law and Crime. We'll be back live with more testimony in just a moment. And you heard it there, folks. The judge calling for a 15-minute morning recess in the Richardson and Hayes case out of Florida. Again, it's a murder case involving the death of a 22-month-old infant named Aiden McClendon. Jonna Spilbor is still here on the Law and Crime Network. Jonna, look, we're starting to get somewhere with the matching up of guns and bullets, but it's going to continue for a while. There's a link, but it's not as strong a link as perhaps we would like.
But I think it's as strong as it's going to get. And I'm almost surprised now, listening to this expert who's doing a really good job with what he has, I'm surprised that the prosecution was thinking of closing without bringing him on. Because, look, he's got to connect a couple of the dots for us. Number one, we know the types of bullets that killed this innocent 22-year-old infant. Now we have to determine which gun they came from, and then we have to determine who was pulling that trigger, basically. Because, as you know, the person who owns the gun isn't necessarily the trigger person, right? It happens all the time. If your gun gets stolen, God forbid, something happens to you. So this expert's doing a good job of now connecting the bullets with the actual weapon, and the jury needs to hear that information.
Yeah, okay, now, one thing I want to ask about is like transferred intent. So one of the theories of this we hear is that the intended victim was actually Aiden McClendon's uncle, but Aiden McClendon, the 22-month-old, was the one who was shot and killed. So explain how we get murder charges for the two defendants when the person that they allegedly were trying to hit wasn't the one who was hit.
Very simply, because the law is smart. For example, if I decide to shoot you right now and I miss and the bullet goes through that wall and I hit Virginia, one of our lovely producers, would never do that. But if that happened, and
You'd never hit her, but you would me?
No, you
I
either.
think that's what you just said.
I plead the fifth.
Okay.
No, so if that were the case, and my defense was, well, I really meant to shoot Aaron, I am still guilty of murder because I intended the reckless and dangerous act of pulling the trigger and hitting a person. I just missed you and hit someone else.
So that's how we get there. Okay, we're going to listen to some of the previous testimony here. Tomashia Brown is the victim's mother. We want to listen to some of her testimony while we wait for this 15-minute break to wrap up. Testimony there from Tomashia Brown, the mother of Aiden McClendon, the 22-month-old who was shot and killed in Florida, the victim in this trial of Kwame Richardson and Henry Hayes. Jonna Spilbor still with us here on the Law and Crime Network. Here we have emotional testimony.
Yeah.
This woman lost her child. The child wasn't even 2 years old.
Yeah, I know. This is your heart breaks for this woman. Hopefully her testimony will be helpful to the jury because she basically identifies the shooters. You know, I can imagine, put yourself at this scene. A spray of bullets, more than one shooter. Your child is in a car seat, I guess parked on the street. You don't know which way is up, but she had the wherewithal to at least see somebody leaning out of a window and shooting a gun, and she's able to identify him as Mr. Hayes, one of the two defendants here, and that should be very helpful to the jury.
You know, time slows down in court, so we
Yes.
hear these lengthy descriptions of this is what happened and that's what happened, and it'll take sometimes an hour to get through what surveillance video indicates happened in 5 seconds.
Right.
And the surveillance recording that shows this going down, it starts and it's over.
Yes.
I mean, this was a blast of bullets. It was almost over as quickly as it started.
Yes, and that's the one thing that might be helpful to the defense is
Questioning whether this identification is correct.
how reliable is this identification? Because you have, just be her for a moment. This is all happening. Your child is away from you where you can't protect it. Now all of a sudden you're in mom mode. Are you really seeing what you believe you saw? And innocently, I'm not saying she's up there lying. I'm saying innocently enough, is her recollection accurate based on the severity of the circumstances? That's what the jury's going to have to
She
decide.
seemed pretty sure of herself. I mean, we've seen some witness identifications where there's a little bit of a sketchy identification. She seemed pretty sure of herself there. So, look, we're going to continue on with our review of testimony from Tomashia Brown, the victim's mother, as we wait for court to pick up in the murder trial of Kwame Richardson and Henry Hayes. And again, this shooting happened in a matter of mere seconds, Jonah, but the mother is pretty firm about what was going on. She remembers what people were wearing, and of course she had time to kind of go back and look at some of this stuff, I'm sure. But emotional testimony, and this is why we have a couple of jurors who were seen crying throughout the proceeding.
You know what? And I can't blame them. You have a 2-year-old who was shot 3 times. When you read about what happened to this young child and how the bullets hit him and he slumped over, like I'm not feeling good right now just having to recount that because I'm a human, you're a human, and all of those jurors are human. That is natural, and it evokes that from us, and that's okay. You can still make a sound decision as a judge, as a juror, as a defense attorney, as a prosecutor with that kind of emotion because we are not robots.
Yeah, we're going to take a quick break here on the Law and Crime Network. As we wait for this morning break to roll along, we'll be back with live testimony soon. First, this. The mother of a 22-month-old victim testifying there on cross-examination in the murder trial of the 2 men that she says were the gunmen who pulled the triggers there. So, Jonah, look, she's, again, pretty emphatic, and this is a tough cross-examination given the gravity of the situation. Her little boy was shot and killed, but she's really being very clear, I think clearer than a lot of other eyewitnesses that we've listened to about exactly what happened here.
Yeah, I don't think the defense is helping itself right now because she's not faltering. She's like hanging out the window, holding the gun like this, 2 hands. I saw his face, saw the gun, I saw the way he was holding the gun. And so the jury is hearing that essentially for the second time because she said the same thing on her direct examination.
At least one of the juries here, and this is one of these cases where, again, there's two juries, and this might be one of these pieces of testimony that only one jury heard because one guy's hanging out the window, where's the other guy?
Right. And that it dumbfounds me how we are playing musical juries here and how all the players are getting that right. It's very interesting. Normally we would just sever these two cases, have two separate trials, but not the case here.
Yeah, you know, we've seen this in Florida before, and I suppose it raises a question as to what is the most efficient way to try a case. Here, the witnesses have one crack at being on the stand, but it does slow things down for the jury. Is this sort of like a witness right or victim's right movement that we're watching play out? I know that you don't practice there, but, you know, look, these victims, they don't have to come back for a second trial. They have one trial, and it's just the jury's moving in and out.
I would look at it as a victim's rights if you're going to look at it as somebody's rights over another, because if I'm a defendant, I don't want resources to get in the way of me getting a fair trial, right? Look at all the resources that we pour on defendants. If you can't afford an attorney, you're going to get one. These trials cost a lot of money. If you can't afford experts, you're going to get them. So the fact that they're combining two trials to save having to subpoena witnesses again to say the same thing over, while I get it, is it actually fair for each defendant? I'm not so sure.
Well, you're entitled to your opinion. I really want to talk to some more policy people in Florida about exactly how this rolls out and what the policy was behind it. But we've seen it in a couple of cases where there are multiple defendants. They're tried at once, but the juries are brought in and out of the room at different points in the testimony. So we are waiting for court to pick up. We are expecting more testimony from that firearms expert who was on the stand earlier. This morning break is dragging on a little bit longer than we expected. The judge said they were going to come back at 10:45. It's about 6 minutes after that. So back to more testimony from the victim's mother. Here she's on cross-examination identifying the defendants. There we have it, the cross-examination of the mother of 22-month-old Aiden McClendon, testifying about who she says pulled the trigger at the vehicle she was in, ultimately shooting and killing her young son. So, Jonna, look, we've got a couple things wrapped up in this testimony. One is this pretty clear identification. She's adamant that at least one of the defendants was leaning out of the window, firing the gun. And an interesting comparison here, we just covered another case in Lexington, Kentucky, the so-called Marine murder trial, where a member of the U.S. Marine Corps was shot and killed. And there we had a lot of issues with identification, and one of the defense tactics was to say that it was a cross-racial identification where a white woman was trying to identify African-American men, and for better or worse, the science numbers suggest that people have a harder time clearly identifying members of different races. Here, you have an African-American making a clear identification of an African-American. It's just an interesting way to kind of look in the window here.
And you could essentially argue that without that component, without the cross-racial component, that her identification is inherently more reliable than it would have been were it a cross-racial identification. The one thing I would be attacking if I were defending these people is the emotion. Was she busy looking at the shooter, or was she busy looking toward the car where her baby was basically a sitting duck in a car seat? That's where I would be going with this. She's much more composed on cross-examination than she was on direct examination. She's making a good witness. We'll see. Yeah, we're going to take a quick break here, folks. We are waiting for testimony to pick back up again in the Richardson and Hayes murder case in Florida. We are expecting this mid-morning break to wrap up any moment. They have taken a lot longer than we thought to sort of get the ball rolling again. A 15-minute break is now a 25-minute break, and oftentimes that's the way it rolls on. So we will be back with more analysis, and we'll take you back live to court as soon as things pick up here on Law and Crime.
This is Law and Crime.
Only 22 months old, baby Aiden McClendon's life was taken in a flash. Aiden's mother, Tamisha Brown, became emotional as she recounted on the stand what she saw from inside a car with her baby boy the night he died.
It was the one guy that I saw in the back seat, and then Harry Hayes.
You have two shooters. Who was he in that car?
He was in the back passenger side.
Okay.
He was the one that was actually leaning out of the car.
Okay.
Harry, that's the person that was in the back seat.
Okay. shooting a gun?
Yes.
And did you write a statement on that photograph memorializing?
Yes.
And what was that?
He shot and killed my baby.
Kwame Richardson and Henry Lee Hayes are now on trial for the little boy's murder. Prosecutors say the suspects participated in a drive-by shooting, which led to the unintentional death of the 1-year-old. Investigators believe a gang conflict is to blame. Jurors were shown a music video filmed by the gang that both defendants were allegedly a part of. Prosecutors believe the intended target and cousin of baby Aiden was affiliated with the rival group. Both defendants now facing charges of second-degree murder, 2 charges of attempted first-degree murder, discharging a firearm from a vehicle, and shooting or throwing deadly missiles. For Law and Crime, I'm Dan Abrams.
Those are the key facts in this case as we continue to march along. And this mid-morning break that was scheduled to last 15 minutes has now lasted more than half an hour. But this is the way it goes in live trials, folks. We are waiting for things to pick back up, though. Jonna Spilbor is with me here on the Law and Crime Network. Jonna, look, breaks take a little bit longer than expected. We've got this weapons expert testifying that a lot of the bullets were inconclusive when he tried to match them up with the guns. But then he said there was one that was a conclusive match. I'm always skeptical about that, though, because there's a lot of literature out there that says that this process of matching bullets with guns is not a clear science, and therefore isn't as strong of a link as one might perhaps like if one's a prosecutor.
Right. And the jury is tasked with figuring out where the bullets that killed this innocent victim came from and whether it came from one of the weapons that was recovered over the course of this investigation. Those are 2 critical components here. And this witness, though, I think is doing a very good job for a couple of reasons, not the least of which he's, for lack of a better word, and I say this respectfully, he's kind of dummying this down. Because you got to remember, the juries are not expert, and he's explaining it in such a way that even I can understand it, which I think is very helpful for the prosecution.
Yeah, you know, and a lot of the witnesses who do this, they get up and they give these speeches, and then they give them, and they give them, and they give them, and they give them, and then on the 10th or the 20th or the 50th or the 200th, telling the description of exactly how this matching works starts to get more and more boring. It's like the story that you've told 20 times over again. On the 20th telling, it's just not as excited because at first you're like, hey, you got to really hear this. This is really good. And then by the time you tell it the 20th time, it's like, well, you know, I heard, yeah, I guess, whatever. Everybody's already heard this before. This witness, I will agree with you, has been pretty direct with the jury in saying, hey, look, this is the way it works. We're going to go step by step by step. And many of you may already know the difference between this part of the bullet and that part of the bullet. But in case some of you don't, we're going to break it all down. And I think that he's teaching more than he is just reciting something onto the record.
And that is helpful for a number of reasons. First, you don't want your jurors falling asleep during critical testimony because it's either going over their head or it's boring the tears out of them, right? You don't want that. He's at least compelling and explaining it so that when they get back in that deliberation room, they can actually have a conversation and deliberate those facts in an intelligent way. I think that's key for this witness.
I agree. You know, look, this is a court of law, but there's also a bit of a theater element attached to it. And I would just say, you know, sometimes the hardest parts of these trials to watch are the parts where, yes, the bullet matched the gun. And it's like, wait a minute, that's the most important thing. You got to make sure the jury's listening to you. You got to be looking at the jury. You got to make it really clear.
And
so
jury instructions don't cover that. This is factual. Jury instruction tells them what law to apply. These are the facts that they need to understand.
Exactly. We're going to listen to some previous testimony in this case as we wait for things to get rolling again. It looks like this morning break is becoming a long morning break. So, Mary Thomas was the victim's great-grandmother. She was on the stand earlier in this case. Again, horribly emotional testimony, but jurors heard it, and we're going to listen to it again. This is another one of the people who was in the vehicle when the gunfire rang out, and no one was hit other than 22-month-old Aiden McClendon. So, Jonna Spilbor, this is, you know, this is tough. We're hearing this parade of surviving witnesses. It's almost a miracle that these folks all survived.
You know, it is a miracle that they survived. And it's interesting because with all of that going on, bullets spewing through your car, your baby getting hit, thank God we have her eyewitness testimony, the mother's eyewitness testimony. And then you have this poor grandmother here who was hoping that the baby was actually going to be okay, you know, despite getting hit by bullets. It's just such a sad, sad scene. It really is.
It is, but we have people to make eyewitness identifications. Those eyewitness identifications pointed at least one of the two defendants, at least. And onward we go here. Just to let folks know what's happening in court right now, we had a morning recess called about 40 minutes ago. That ended about 5 minutes ago, and apparently the judge is in some kind of a sidebar with the attorneys right now. We're not sure what they're discussing yet because sound is off in the courtroom. But apparently they're trying to get this process rolling again. We're not sure if it's a scheduling situation or what it is just yet. So things are starting to pick up again. We are hoping for more live testimony sooner rather than later here in the Richardson-Hayes case out of Florida. So we're going to take a quick break here on Law and Crime. We'll be back with more analysis and hopefully some live testimony when we come back. Welcome back, folks, to Law and Crime's coverage of the Kwame Richardson and Henry Hayes murder trial out of Florida, where a 22-month-old victim named Aiden McClendon was shot and killed allegedly by these two defendants. Jonna Spilbor is still here with me on Law and Crime. Jonna, I want to talk about a couple of things that change this trial, that make this different, because you have alleged gang members, you have alleged gang witnesses. One of the witnesses was stabbed in jail the day before his testimony. Look, they're in jail, they're in the community. The rule is no snitching, and some of these witnesses violated that.
Yeah, they did. Thankfully, because the witnesses that we could not show, the alleged gang-affiliated witnesses, are essential in this case, really, in order to get a conviction, if we get a conviction. But I got to tell you, Aaron, and I'm going to be serious here, and I'm sure I'm not alone. I would have to take pause before I said yes to being on a jury, like these 24 people or however many there are, when the defendants have gang affiliations for the one reason. For safety, because look, these jurors aren't going to all remain anonymous forever. If they do get a conviction, are they in danger? Is that going through their head? Is that going to color how they decide to rule on this case? These are all very legitimate concerns, and it's a scary proposition.
I agree with you. Look, I mean, some of the changes in American law, keeping juries secret and whatnot, came out of mafia prosecutions and then have expanded in gang prosecutions. This sort of changed the way juries are impaneled and the way information about jurors became protected, because before the mafia prosecutions and then the subsequent gang prosecutions, people pretty much knew who were on juries. You know, and that was originally, if you go way back to the time of the Constitution, look, people mostly in the United States lived in rural communities. People knew who were on these juries. It wasn't a secret. Well, some of these prosecutions call for and bring forth the need for secret juries.
And a case like this, I think, certainly does. And also, look at the age in which we live now. Jurors are in contact with the media. The media, after cases are over, the media's in contact with jurors. Jurors write books. Like, it's not a secret anymore. Juries they're not secret entities anymore. But in a case like this, I would want to be warned when I'm being voir dired, when they call in the hundreds of people to be prospective jurors in a case like this. We have a duty, I think, to warn that it's going to involve some sort of gang violence. I don't think that would be prejudicial to the defense in a case like this, because you've got to have juries on there who are okay with it.
These jurors needed to have been warned and vetted. I agree with that. So let's continue our review of testimony in this case as we wait to see when things are going to wrap up. The morning break lasted a lot longer than we thought, and now there's a lengthy sidebar going on, some kind of discussion between the attorneys and the judge. We are not able to televise it. So we're curious to see what's exactly happening here. But previous witnesses here, Jordan Harris was a witness at the scene of the shooting. This thing happened very, very quickly. It was a spray of bullets. It was over somewhere between 5 and 10 seconds. And we hear the story so many times from so many of these witnesses. It sounds like it took forever to play out, but it was a very quick act. And I think some of this witness's testimony might give us a bit more context into exactly how this played out. Previous testimony in the Richardson and Hayes case out of Florida. It's a murder case, but live testimony is picking up in the courtroom. We do want to say goodbye, though, before we dip back into live testimony to Jonna Spilbor. Thanks for being here.
Always a pleasure. Thanks for having me.
Great to have your insight. But after this lengthy morning break, folks, we are back live with more testimony. This is the firearms expert back on the witness stand. So let's cut back live to court and bring you back as they try to match up the bullets with the guns.